Good morning and welcome to this session on capacity to contract. Now, in this section, we would like to understand the rules concerning capacity to contract, how contracts may be made by natural persons, that is individuals, in particular minors, those who might be under the influence of alcohol or any other substance, and also those suffering from mental illnesses. How exactly would contracts of that nature be regulated by law? Secondly, we also would like to understand how legal persons have the capacity to contract a contract and when they do not. So to begin with, capacity is the legal ability to enter into a valid contract. And the law seeks to protect those without capacity to do so. And this is because those are considered to be minorities, they are considered to be legal disadvantaged, and because of that, those type of contracts are considered unenforceable, voidable at law for all practical intents and purposes. Let us begin by discussing the question of contracts which are valid and enforceable against minors versus those which are not. So a minor obviously is somebody under the age of 18. And at law, there is what is known as necessaries, that is, goods which a minor needs, which are considered to be essential for that particular minor. Okay, so the law would not intervene in that type of a contract where a minor is entering into a contract in order to acquire. So the necessaries we're talking about here are those goods that traditionally are accepted that minors would require, depending of course on their type of situation in life, their social standing. These are deemed to be necessary. So a contract for necessaries can be enforced against a minor. They would not escape liability. And if you look at the case, an Old English case which we have as an example, the case of Chappell versus Cooper of 1844, you will see that there was a minor who was married. In fact, in those days it was quite normal to find a 17-year-old or 16-year-old being married. But unfortunately, her husband, who was much older, died. And she now was left with the responsibility of employing, the funeral services, arrangements, and so on. Later on, when she was unable to pay the bills, she tried to rely on the fact that she was a minor, and therefore this contract could not be enforced against her. Court held that this was a necessary, and in fact that because it was necessary and it was something required looking at the circumstances, she was definitely liable, and the contracts that she had entered into were in fact enforceable. So necessary in the legal term is quite a specific term which also means the same as necessity. In this case, clearly, she did have an obligation to meet the payments. So the goods of services, as long as they are necessary according to an individual's station in life. Let's also consider the case of Clements versus London and North Western Railway Company, 1894. Interesting case where a minor took up employment as a porter in the railway, and he agreed to join the company's insurance scheme, and in which he would relinquish any rights which he would normally have had under the Employers' Liability Act, which is a British act. In the event of an accident, the scheme would have given him much, much more than the Employers' Liability Act. This is why he preferred to go under the scheme and have better compensation. But when the minor had tried to claim under the employer's scheme, the action failed because he was deemed to be a minor. So in that particular incident, he couldn't succeed in bringing up an action under the Employers' Liability Act, which he had. He preferred the scheme rather than the act. So we're looking at examples where minors can be liable, where minors can have contracts enforced against them. A contract which is voidable against a minor. There are a few incidents where really the minor cannot be deemed to be signing on their own behalf. And that is where it is a contract to lease a property or a contract to buy and sell shares in a public company, and a contract to enter into a partnership agreement, and a contract for marriage settlement, marriage itself. Those are instances where. Let's also consider the case of Clements versus London and North Western Railway Company, 1894. Interesting case where a minor took up employment as a porter in the railway, and he agreed to join the company's insurance scheme, and in which he would relinquish any rights which he would normally have had under the Employers' Liability Act, which is a British act. In the event of an accident, the scheme would have given him much, much more than the Employers' Liability Act. This is why he preferred to go under the scheme and have better compensation. But when the minor had tried to claim under the employer's scheme, the action failed because he was deemed to be a minor. So in that particular incident, he couldn't succeed in bringing up an action under the Employers' Liability Act, which he had. He preferred the scheme rather than the act. So we're looking at examples where minors can be liable, where minors can have contracts enforced against them. A contract which is voidable against a minor. There are a few incidents where really the minor cannot be deemed to be signing on their own behalf. And that is where it is a contract to lease a property or a contract to buy and sell shares in a public company, and a contract to enter into a partnership agreement, and a contract for marriage settlement, marriage itself. Those are instances where. And so with minors, there are certain circumstances, as I've mentioned, the 4 situations, that is where a minor is signing a lease agreement, trying to buy and sell shares of a company, and other circumstances. It is not prudent to enter into such a contract with minors. That is because they really have no capacity to enter into very serious legally binding contracts of that nature. Unless an adult were to sign, or a lawyer as friend of court, on their behalf, so that then it becomes a valid contract. The reason why, of course, at equity, minors cannot be held liable is because of a protection that the law puts in place to protect them against unscrupulous businessmen, business people who would want to take advantage of the age of the person. The law dictates that the other party to the contract, being the minor, would require such type of protection, and traditionally it has been held to be so. So a minor is liable for contracts which are necessaries, for contracts of service, education, training, and so on, but not to lease a premises, not to buy and sell shares in a company, not even to join a partnership agreement, and not even for a marriage settlement. They can't say, if this marriage fails, I will give so much property. They can't. So if it's for goods and services which are other than a loan, other than essentials, or for a loan, or for other type of. So with minors, we have seen that if the contract is for goods or services which are other than necessaries, if it's for a loan, if it's for an account, which is just personal between parties, it cannot be enforced against a minor. But where there's property involved, if it was wrongfully signed, then such property may be recovered because the contract was voidable to start with. And so that concludes our consideration of minors, that is, children who do not have, in many instances, capacity to contract. Let us move ahead now to the capacity of mentally disordered persons. And with mentally disordered persons, if you look at the Persons with Disabilities Act here in Zambia, you'll see that the definition not only is for mentally, but the definition of a disabled person in Zambia includes all disabilities. But we're now focusing on those with mental disabilities because of the doctrine of freedom to contract. Freedom to contract in contract law necessitates that an individual must give their consent and must have an ability to think logically about the actions they're taking and their consequences. Hence, the concern with mentally disordered persons. So a mentally disordered person cannot reasonably have capacity to contract. And there are several cases which demonstrate this point. I can give you one British case, the Imperial Loan Company versus Stone, which is an 1892 case, which demonstrates. Yes, I've cited the case of Imperial Loan Company versus Stone, 1892 case, in which we see that at the time of entering into an agreement, the other person was in fact aware of the mental incapacity of the other party. So please read the case. I won't give you the facts of all cases as we go along. Please do some research. And I'll also look for some Zambian cases. I think we have quite a few in this particular area. The other category of natural persons lacking capacity to contract are those who are drunk. So now we're talking about, alcohol consumption and substance abuse. In short, it is a situation which is considered to be temporary, in the sense that those who are intoxicated at some point will be sober. So it's not a permanent situation, but the concern of the law is where an agreement is entered into during that state of intoxication, during the state of drunkenness, where the mental capacity, the ability to think logically, to give their consent might be swayed because they are now in that uninhibited state of mind where they can be easily persuaded to enter into an agreement by some people trying to take advantage. You can imagine that billionaire uncle who is highly intoxicated on a particular day and is being persuaded to sign over something which ordinarily would not do. Or you can imagine, somebody who is not really. So a party who is drunk and enters into a contract is given certain protections because of the fear at law that there could be other parties trying to take advantage. See the case of Matthews versus Baxter, 1873, and also Gore versus Gibson. I was trying to give you practical examples where you can imagine, others, those who are drunk being taken advantage of. What the law will do is that if, at common law, if that drunken party who had signed an agreement is now sober and still agrees that he's satisfied to implement the terms of a contract which were signed under the influence of alcohol, then the law will consider it to be so, Of course, because contracts are based on the principle of freedom to contract. So having sobered up, if that party still feels that they are satisfied enough to go ahead, then common law will recognize that that contract is valid. However, where a party was so drunk, and actually even after sobering up, it is very unlikely that they would want to go ahead with this contract, then the law will also support that and invalidate the contract, and he would be able to repudiate such a contract which had been entered into during a state of intoxication. So because of the fact that intoxication is a temporary state, the law gives certain protections to parties who were being taken advantage of during that state of drunkenness, and therefore consider that Now let's discuss the capacity of corporations or companies. These are legal persons, A company enjoys legal personality, and when you look at the company, we're looking at a body which is accepted as having its own separate legal personality. You remember the case of Salmon versus Salmon in your company law. So because it is a legal person, it does act like a person. And what will give us its mandate, as it were, are the articles of association. So we rely on the articles of association during the process of registration, or depending on whether it's a statutory body, we would want to look at the statute itself, or if it is a company created by a royal charter or by any other government instrument, we would be looking at the constitution of that legal person in order to see what are the restrictions, the limitations of this company at law, which were designated at the time of registration or incorporation or formation or establishment. That is what will guide us in determining whether the legal person has capacity to contract certain contracts or not. And so when we look at that, we now come across the idea that a company can only or is restricted to certain actions. They have certain objectives and certain purposes, which they themselves have set out at the time of its establishment and creation. Now, the ultra vires doctrine teaches us that when a corporation or a corporate entity acts... the ultra vires doctrine teaches us that when a company or a legal corporation goes beyond its capacity, which itself had set out within its constitution, then it is acting outside its prescribed objectives. And at law, that is known as being ultra vires and therefore void and unenforceable, because it is defeating or it is outside the actual purposes which it set out for itself. I'm sure many of you have been to PACRA to register a company, and at a certain point you are told you must fill in at least 2 or 3 purposes of that company. So if you say, yes, you're creating a company which is going to supply fish, chicken, meat products, that is fine. So the same company cannot now purport to be supplying vehicle spares, truck components, industrial mining equipment, because the objects of the company were to supply meat products. How then is that company now moving into industrial and mining equipment? It becomes ultra vires its own constitution. So this is why it's very important to look at the constitution of the legal person, and that is what will tell us what that company is legitimately supposed to be doing. The landmark case in this regard is the case of Ashbury Railway Carriage Company versus Risch of 1875. And this company was created to carry out the building of railway stock and was an engineering company. The case of Ashbury Railway Carriage is a landmark case in the doctrine of in learning the ultra vires doctrine, which teaches us that legal persons must act within their own prescribed objectives. So, as I was saying, this company was an engineering company. The directors, however, contracted a concession that they had bought to build a railway in Belgium for a Belgian contract and a company, but they failed to honor their agreement. And when the Belgian company brought an action to enforce the agreement, court held that in fact there was nothing in Ashbury's objectives allowing it to build railways, and so the agreement was in the first place ultra vires and actually void. This was an engineering company and it was there to build railway stock, but it was not there to have a concession and build a railway. So railway stock is different. I think these are the railway wagons and things, but not to do the actual construction of a railway line. That was outside the purposes of the company. And even when we learn constitutional law and other laws, this is the landmark case which is used to demonstrate that a company must really fit in the objects of its own constitution. Otherwise, courts will not recognize such an agreement as binding. In summary, a company is governed by its own constitution. It is governed by its own constitution, and obviously companies are established, set up for specific purposes. And once you go outside these purposes, it's deemed to be ultra vires, and that company is said to have no capacity to enter into the type of contract that it has. I would like to remind you that we've gone through individuals and legal persons. And in your revision and in your studies, please look at the summary of the chapter on capacity, which starts in your textbook at page 323. Read the cases separately. I've given you cases for minors, for those under intoxication, and for mental illness, as well as companies. Read the cases in your own time. When we don't meet in between lectures, that's the time for you to do some revision. Because in an exam question, when answering a question, you're expected to cite a case, and when you cite a case, at least to say something about that case. Who were the parties? What was the circumstances, and what was the decision arising from the case? So I hope to meet you soon. We have challenges with network and with the load shedding situation, but please continue studying, and I look forward to our next session. Thank you.